Good afternoon, everybody. This is the time and place for our regularly scheduled business meeting of the Montana Public Service Commission. Today's date is Tuesday, February 21st, 2023. Time is now 1:30 p.m. Would the other commissioners join me in reciting the Pledge of Allegiance? All right, thank you, commissioners, for joining me in reciting the Pledge of Allegiance. I would note for the record that Commissioner O'Donnell, Commissioner Pinocci, Commissioner Bukacek, Vice President Fielder, and myself are all present today in the Bollinger Room here at the PSC, so we do have quorum. The Montana Public Service Commission welcomes public comment on any matter that may be on the agenda this afternoon or any matter that is within the commission's jurisdiction. Are there any public commenters in the room? If so, please step forward. Seeing none, are there any commenters online? There is. To understand, Mr. Jack Windsor, like to make public comment. Can you hear us, Mr. Windsor?
Yes, sir. Can you hear me?
Yes, we can. Go ahead and identify yourself, spell your name, identify who you're with, and provide your comment. Thank you.
Awesome. Yeah, it's Jack Windsor, last name Winsor. I'm here talking about the Clydesdale junk removal case. I was up there 2 weeks ago on the case previously, and I'm just fortunate to have the ability to speak one more time on it. After last week and everything that was kind of said and what we discussed, I just was wanting to have this opportunity to clear up a few things after this last one. It had been stated that there was a possibility that I did weekly trash pickup and that was part of my business, and that is not part of my business. Everything I do is either junk removal or just kind of clean out type debris stuff. So none of that necessarily falls under that weekly pickup. But the one thing that I did want to talk on was the talk of not needing that Class D license. And I've gone through this over the last few months before we've gotten to this point, going back and forth. And I know that what I had talked about was just the cleaning out of evictions and foreclosures and that type of stuff. But another large portion of what I do is the junk removal side of things. So not necessarily the cleaning out of those homes or anything. So in that, I can be called for a couch. There are multiple different things that a homeowner or a business can call me to come and pick up. So while I don't do that weekly pickup or those types of things, I still am actively transporting refuse for either homeowners, individuals, or just companies in general. So I just wanted to kind of make that clear before that piece was rolled on. And the other thing was that after questioning, after I was able to speak, it was relatively clearly brought to our attention the way that it was handled the last time, and it had been made sounded like maybe the commission had not followed all the rules directly. But as far as it sounded to me, it sounded like me and the commission all followed the protocols to the extent that is required. So it seems as if everything was notified in a timely manner and that everything was followed to a T. Those protests had ample time to either protest and or within those 14 days, had it been shorter, even though they were notified, had the time to submit this motion before the deadline had come up. So I just wanted to touch on those things before kind of the rulings were made and everything was decided on.
All right, thank you, Mr. Windsor. Is
Yes,
there,
sir.
Is there additional commenters online? Seeing none. All right, we do have one announcement this afternoon. There is one change to the work session items. Work session item number 5, which is Northwestern Energy's 2023 Electric Integrated Resource Plan. The commission initiated to put out an RFP that is going to be deferred to our next meeting. So we will not be taking up work session item number 5. Let's move into our action items. Action item number 1 is approval of the commission minutes for the week of February 7th, 2023. Is there a motion, Vice President Fielder?
Mr. President, I move adoption of the commission minutes for the week of February 7th, 2023.
Is there a second?
I'll second.
Commissioner Panochi has seconded. Discussion, changes, revisions to the draft minutes? All right, seeing none, we'll go ahead and vote to approve the commission minutes for the week of February 7, 2023 as drafted. All those in favor of the Vice President's motion signify by saying aye.
Aye.
All those opposed signify by saying no. Seeing no opposition, minutes for February 7, 2023 are adopted. Okay, our second action item in the morning. Afternoon. This change up has thrown me off. Is staff out of state travel. Mr. Rosequist is under the weather this morning, so I will be presenting this action item. So action item number 2 on today's agenda is a request for approval for Joel Tierney and John Torski to travel to San Diego, California. The dates of April 24th, 2023 through April 28th, 2023 to attend the Western Regional Meeting of the National Association of Pipeline Safety Representatives, an APSR. During this meeting, state pipeline safety representatives will hear from Federal Pipeline and Hazardous Materials Administration, otherwise known as PHMSA, personnel regarding new agency directives, grants, state program guidelines, and support tools, and they will receive updates regarding training and qualifications requirements. In addition, each state will report on its pipeline safety program activities, challenges, and successes. Representatives from the commission will learn about and discuss integrating operator inspections using the GIS system, PHMSA accident investigations, methane recovery systems and operation, and will learn about impacts to pipeline infrastructure from natural disasters, among other subjects. Total expected cost of this out-of-state travel will be $4,500. This money would be paid out of our federal pipeline safety grant, and there will be no impact to our special revenue allocation. I would note that this training is required as part of Mr. Tierney's and Mr. Torski's certification, so it is somewhat imperative that we approve this. So I will move to approve travel for Mr. Tierney and Mr. Torski to travel to San Diego, California in April for required training. Is there a second?
Second.
Commissioner O'Donnell seconded. Discussion? Seeing none, all those in favor of my motion to approve travel for our staff signify by saying aye.
Aye.
Aye. All those opposed signify by saying no. Seeing no opposition, staff travel is approved unanimously. Thank you, colleagues. Let's move into our work session. Work session item number 1 is docket 2023.01.009 Clydesdale Junk Removal LLC. This is application for certificate of public convenience and necessity. We're here to consider Evergreen Disposal Inc. and Waste Connection of Montana Inc.'s motion for late protest. We're here to consider if, no, I think that's been determined. So we're here to consider the motion for late protest. You have the floor.
Thank you, President. Commissioners, this matter today came before you 2 weeks ago. Before you today is a revised draft notice of commission action in docket 2023.01.009. Before discussing staff recommendations, I will start by revisiting the important procedural history in this matter. Clydesdale applied for a Class D Certificate of Public Convenience and Necessity in December of 2022. On January 13th, the commission published its notice of application and protest deadline, establishing January 27th as the deadline for protest. The following week, on January 30th, 2023, the commission received a late motion from protestants Evergreen Disposal Inc. and Waste Connections of Montana Inc. doing business as Bitterroot Disposal. The motion requested an extension of time to file protests and alternatively a request for hearing and intervention. During the regularly scheduled business meeting 2 weeks ago, the commission had discussion and concern about the commission's regulatory jurisdiction over the services that Clydesdale proposes. As the president just mentioned, staff did research into that and provided a memo in your meeting materials today concerning the jurisdictional question. Staff has determined the information presented in Clydesdale applications and during public comments confirm that the commission has or likely has jurisdiction over this matter and should proceed to the substantive decision presented in the notice of commission action. Moving to the notice of commission action, staff recommends admitting Evergreen and Bitterroot as protestants for good cause. Technical error occurred with commission notice to interested parties. Notice was published late in the commission's weekly agenda. The notice was not timely distributed via email to the motor care interested party list as a result. Further, Evergreen and Bitterroot have a direct and substantial interest in the application because both protestants currently provide Class D garbage hauling services in Clydesdale's proposed area. Because the technical error and because staff does not believe protest will affect the commission's ability to make a decision within the 180-day statutory deadline, staff recommends admitting Evergreen and Bitterroot as protestants for good cause. Staff recommends adopting the draft notice of commission action and allows staff to make any necessary non-substantive changes.
Thank you. Is there a motion? Commissioner Bukacek.
Thank you, Mr. President. I move to admit Evergreen Disposal and Waste Connections of Montana into the docket 2023.01.009 as late protestants for good cause.
Would you like to add to that motion to allow staff to make any changes to the draft?
Yes. I need to repeat that.
No.
Thank you.
Is there a second? Mr. O'Donnell has seconded. Discussion. Vice President Field.
Yes, Mr. President, would it be all right if I ask Mr. Poco a couple questions?
Proceed.
Mr. Poco, did you hear the comments from this applicant today or from Mr. Windsor representing the applicant today?
I did.
And did his comments in any way change staff's assessment of the PSC jurisdiction over this company?
They did not.
Thank you. And then regarding the notice, the applicant stated that he thought that the notice had been met. So I want to talk about that a little bit. A technical error occurred. There was 2 forms of notice that are normally required for this type of application. Is that correct?
That's correct.
Okay, where are those notices usually or required to be?
The first notice is a notice in newspapers of circulation in the affected areas. We did that. However, that was also slightly delayed. Protestants in their motion noted that they did not notice those newspapers until about a week before the deadline. The second place is going to be in the commission weekly agenda. We did not have that timely noticed in the agenda, and thus, as a consequence, it was not distributed to the Class D motor carrier interested party listserv, which is the normal process when posted as a notice agenda item.
Okay, thank you. I appreciate that. It's unfortunately not the fault of the applicant or the protestants that we find ourselves here. But I'm going to support Commissioner Bukacek's motion simply to ensure that we allow these parties in as late protestants due to the scheduling or the notice conflict that we had, the delay of it going out. They filed protests 2 days after the deadline, but our notice is later than 2 days, so I'll support the motion today.
Thank you, Vice President Fielder. Additional discussion? All right, seeing none, all those in favor of Commissioner Bukacek's motion to grant Evergreen Disposal Inc. and Waste Connection of Montana Inc.'s motion, signify by saying aye.
Aye.
Aye. Seeing no opposition, motion carries unanimously. Thank you, Mr. Palco. All right, let's move to work session item number 2. This is city service Valcon. This is a commission initiated matter relating to pipeline safety. We're here to consider issuing an order to show cause as to why the commission should not take steps to sanction city service Valcon for failure to adhere to pipeline safety standards. Mr. Tierney.
Morning, Mr. President and Commissioners. Before you is City Service Valcon. They are a small propane operator that operates in Lakeside, Montana. They serve 85 customers in the waterside condos that are at Lakeside. City Service Valcon contracts with the Waterside Users Homeowners Association to operate the system. The homeowners are the owners of the system. City Service is the operator of the system. They've entered into a contract when the system was built to fill the tank and also to operate the utility system that goes along with it. In the beginning, City Service did a pretty good job of keeping up with what was required, but as time has progressed and more things that needed to be done, City Service seems to be not focusing their efforts on where they need to focus their efforts on the utility side and focusing their efforts on the bulk propane delivery side. The City Service Valcon is a fairly large company, and they fuel, jet fuel, gasoline, and then they propane, and they have bulk propane. They have propane customers all over Northwest Montana, I believe. So they're a very busy company doing that, but that does not mean that they can't, or they're not supposed to be doing what they're supposed to be doing on the utility side. The system. We have been visited with them over the last year and a half, multiple times, multiple on-site visits. We have given them multiple opportunities and multiple information as to what they need to comply with the regulations. Again, it's a small system. Basically, the jurisdictional pipe, 100 feet. Tank is buried. It's on private property. It's right next to the condos. There's 100 feet underground pipe that goes into the building. And then buried tank that's also jurisdictional. They are required to do certain maintenance functions on. Sam has been up there the last couple of times. We issued him the probable non-compliances, which is standard format that we would use. We would go in, and we find deficiencies. We issue what's called a notice of probable non-compliance, and then by rule, they're allowed 60 days to respond to that. And 60 days had come up with the last one, and the responses were really fairly dismissive to a certain respect. One major thing is the testing of a relief device on a tank. They quoted a wrong standard that said that they were required to test that relief, which is not the case. They're required to test it. We have 5 propane utilities in the state of Montana. For instance, Energy West operates a smaller one at Hardy Creek. We did the same inspection with them, and to be quite honest, before we were back in Helena, they were half the violations were fixed, and they were on track to get stuff done. So City Service, the next step in the enforcement process is to staff request that the commission issue show cause, where that would require them to come in with some type of a detailed plan to explain to us why they either feel that they can spend as much little of time on it or they don't, or what kind of plan they're going to come up with to comply with the regulations. We had routed a memo that was written last week that kind of gave a background, and Dan had drafted a draft or show cause that's sitting before you. Our recommendation is to make sure that they comply with the pipeline safety regulations. I will say this is not a normal thing. You know, we have very good operators in Montana. 99.9%. They correct violations. There's an instance, and this is an instance that we have to move to the next tool in the tool bag to get to.
Thank you, Mr. Tierney. Is there a motion, Commissioner Bukacek?
I move that we issue an order to show cause and require City Service Valcon to demonstrate compliance with safety standards.
Is there a second?
I'll second the motion, Mr. President.
Vice President Fielder has seconded. Discussion. Commissioner O'Donnell.
Yes, not to imply any less of seriousness because of maintenance records, but is there any indication of any heightened safety issue here?
No, Commissioner O'Donnell, no. And that's what we want to make sure that we don't get to that point. They do some of the maintenance on it. They just are not very good about documenting it. And then from our standpoint, when we go out and we do something and we something is required of them to do, and we say, did you do this? And they say, yes, then they must provide a record for us that they did that, because in our eyes, if they can't provide a record, then it was not needed. So I don't believe that all is getting done, but I do believe that some of it's getting done. And I do not believe that there's any concern. We just want to make sure that we don't get to a point where there's something.
Thank you.
Additional discussion, Vice President Fielder.
Thank you, Mr. President. I appreciate that question and response, Mr. Tierney. I also appreciate the way that staff tries to work cooperatively with these folks because the goal is safety. And it's, I think it's wise to be proactive in this as you're asking us to do. So I'm going to go ahead and support this motion as well and hope this company can become a little bit more responsive and serious in documenting the work that they are doing so that we can identify if they're not doing it and head off any potential safety problems that could affect our fellow Montanans in that area.
Additional discussion? Seeing none, all those in favor of Commissioner Bukacek's motion to have the commission issue an order to show cause, signify by saying aye.
Aye.
Aye. All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. Thank you. Thank you, Mr. Tierney. Okay, let's move to work session item number 3. This is docket 2022.06.064. This is Northwestern Energy. This is Northwestern Energy's application for approval of corporate restructuring. We're here to consider acting on the parties' joint motion to approve the settlement in this docket. Mr. Hamilton.
Thank you, Mr. President and Commissioners. If I may have the President's indulgence just for a bit of housekeeping before I begin. I believe earlier you mentioned that work session item number 5 was Northwestern Energy's integrated resource plan. And I believe that there's a discrepancy between the agenda before the commission and the agenda that is currently posted on the commission's website. So in the interest of clarity, I would note that agenda item is number 6, and that we currently have an agenda item number 4 in docket 2019.10.076 CED Wheatland Teton Pond Array that I believe is in fact not going to be addressed today. That'll be deferred. Is that correct?
Thank you, Mr. Hamilton, for pointing that out. That is correct. The CED matter should have been taken off the public agenda before today's meeting. So thank you for that correction.
All right, then in that case, commissioners, I'm here properly to discuss the Northwestern Energy application for approval of corporate restructuring, and in particular, the joint stipulation settlement agreement that the parties entered into and filed with the commission last month. You'll recall that Northwestern Energy went through a period of time in the early 2000s through a period of bankruptcy where, as a result of perhaps the deregulation of energy in Montana, we were in a position, or Northwestern Energy was in a position where it couldn't meet its obligations and had to file for bankruptcy. As a result of that bankruptcy, the commission, the Montana Consumer Council, and Northwestern Energy entered into a stipulation referred to in your draft order as a bankruptcy stipulation,
that imposed certain ring fencing measures on Northwestern Energy to help protect the assets of the Montana utility from other risky investments that would otherwise tend to, well, create the same problems that we saw leading up to that bankruptcy. So the Northwestern Energy ring fencing measures imposed as part of that bankruptcy stipulation prevented the company from splitting into what you would see as a traditional sort of utility corporate structure, having a holding company and various subsidiaries, affiliates that would actually provide different types of service, in this case, utility service to its Montana customers. So as part of this Northwestern Energy application for corporate restructuring, Northwestern describes the process as a sort of paper transaction. So to restructure their company to create a holding company, the Northwestern Corporation would continue as the Montana utility that provides Montana utility service. And then there would also be a Northwestern Prairies Corporation, which provides utility service in Northwestern's other service area, which is in Nebraska and South Dakota. The idea here is to allow Northwestern Energy greater flexibility and to adopt the sort of corporate structure that you see across the energy industry right now. There were 10 key disputed items as part of the intervention testimony that we received in this docket from the Montana Consumer Council and the large customer group. So with the commission's indulgence, I'll just briefly run through each of those 10 disputed issues and how the parties dealt with that as part of the stipulation and settlement agreement. The first disputed issue was a restriction on dividends, the ability of the Montana utility to issue dividends up to its parent company, the holding company, which would be the sole shareholder receiving dividends from Northwestern Montana utility under this agreement. Montana Consumer Council proposed a variety of dividend restrictions to prevent dividends from being issued if the issuance of that dividend would cause the equity structure, the percentage of financing of the company by equity to fall below a certain threshold. And if there was if the credit rating, the long-term secured debt credit rating of the company fell below a certain threshold. So the joint settlement, the stipulation that you have in front of you, which I believe in your draft order is referred to as the restructuring settlement, that adopts many of MCC's proposals here. It incorporates some triggers that would prevent the company from issuing dividends up to the parent company if it would affect the equity held in the Montana utility below a certain threshold, or if the Montana utility's credit rating fell below investment grade. So those are two important restrictions that are carried forward through the joint stipulation. Staff has reviewed that dividend restriction and recommends that the commission find it just and reasonable under the circumstances of this settlement. And perhaps the best way to do this is to pause after each one of these 10 disputed issues and see if there are any questions from the commission before I continue.
Excellent suggestion. Are there any questions on this issue? All right, seeing none, please proceed.
The second disputed issue was the matter of credit rating, and in particular, what happens if the credit rating of the Montana utility falls below a certain threshold. Again, this was proposals recommended by MCC. The stipulation largely adopts, sorry, I keep on referring to it as a stipulation. It should be clear in my language. The restructuring settlement adopts many of the MCC's requests here with regard to the credit rating. And as a result, if the credit rating of the Montana utility drops below a certain threshold, they will provide notice to the commission. They will also initiate a docket to review a plan for improvement of fixing the credit rating of the Montana utility if need be. Fortunately, we're not there currently, and we would, of course, hope never to be there. But if that circumstance does materialize, there'd be notice and a process in front of the commission to address the problem. Any questions about the credit rating?
Questions? Please proceed.
Next, the third issue, at least in the organizational scheme of the draft order, is separate entities and the concept of maintaining separate entities. This is a very important one. It means that the Montana utility, that Northwestern Corporation that provides Montana utility service, has to maintain a separation from the holding company and from other affiliates. So Northwestern Prairies, for example, or any future subsidiaries of the holding company that would come into existence, they have to maintain separate books, separate cash flows. They can't commingle funds. They have to maintain separate debt obligations. The liabilities of the Montana utility would be protected from the liabilities sorry, let me take this again. The assets of the Montana utility would be protected from the liabilities of any of these affiliates, and thereby ensure that we don't have any sort of cascading problems that would impair the ability of the Montana utility to provide service. Again, staff has reviewed the proposed terms in the settlement agreement and finds that they are just and reasonable, and recommend the commission find the same.
Questions, colleagues? Seeing none, go ahead.
Moving on to the sale of utility assets. Under the bankruptcy stipulation, there was a $5 million threshold imposed upon any sale of the utility's assets, which would begin a process in front of the commission for review of that $5 million transfer. Under the terms of the joint the restructuring settlement, that threshold would be increased to $10 million. At $10 million, Northwestern would have an obligation to provide notice to the commission of the sale of those utility assets. So this is largely a reflection of the changing value of the dollar since the bankruptcy stipulation was put in place. Staff has reviewed this term, believes that an adjustment up to $10 million is reasonable and just, and therefore recommend the commission find the same.
I do have a question on this one, Mr. Hamilton.
Yes.
So if I recall correctly, Northwest Energy's original request was to have threshold set at 25 million. Do I recall that correctly?
Mr. President, I believe that is correct. Yes, that was their original request.
And so the party settled at 10 million. Is that?
That is correct. They came down substantially from Northwestern's original request.
All right. Thank you for that clarification.
Moving on to cost allocation. MCC and the LCG, the large customer group, both proposed the development and presentation of what's called a cost allocation manual, which would address how costs for the holding company would be spread across each of the different subsidiaries, how costs of the subsidiaries that may be providing, well, how costs in general would be allocated across all the different corporate entities involved in this restructuring plan. Of course, the question of cost allocation is already pending in front of the commission as part of Northwestern's general rate case. In the context, at least, of the restructuring docket, the parties have agreed that it would be appropriate to address the creation of a cost allocation manual after the commission considers cost allocation as part of this general rate case. And as a result, under the terms of the restructuring settlement and under the terms of the draft final order in front of you, Northwestern Energy would be required to submit within 90 days of the conclusion of the general rate case a compliance filing that details their proposed cost allocation manual. If it becomes necessary for the commission to conduct additional process tailored to that cost allocation manual, that is something that the commission can consider at that date. But as of right now, the parties have agreed that this can be dealt with after the rate case. Staff has reviewed that and agrees that that is a just and reasonable result. So staff would recommend the commission find the same.
Questions? I think you answered my question, but I'll reiterate the point that the commission will still retain jurisdiction to determine the adequacy of the post filing, correct?
That is correct. Mr. President, commissioners, nothing within the approval of the restructuring settlement here is a waiver of any of the commission's jurisdiction over, well, everything that the statute allows you to do. So that is made clear in this draft final order. I don't think it was really a question in the restructuring settlement that it was an attempt to limit the jurisdiction of the commission, but just in case there was any vagueness there, the draft order does make clear that you're retaining jurisdiction.
Thank you, Mr. Hamilton.
Moving on to special purpose entities and the concept of a golden share. This was a proposal from the MCC. LCG had a slightly different take on the concept of a golden share, but the principle is the same, where you'd be taking additional steps to try to insulate and prevent the issuance of dividends or other decision-making at the Montana utility level through the creation of this special purpose entity and through the use of a golden share where there would be one particular member of the voting panel that had special rights to decide a vote or to veto a certain action, for example, in bankruptcy filings or similar actions. The Northwestern Energy responded to those requests by pointing out that the concept of a special purpose entity, the concept of a golden share, are really designed for M&A, mergers and acquisitions sort of transactions, which this is not. This is a internal restructuring of Northwestern Energy. And as a result, the joint settlement agreement here appears to not include any aspect of a special purpose entity or the concept of a golden share. Staff has reviewed that term or the absence of that term and does find that, at least as Northwestern has explained it, the SPE, the special purpose entity, and golden share are really not applicable at this stage, and therefore has no qualms about approving the settlement agreement in the absence of that SPE or golden share requirement. Of course, the commission would retain the jurisdiction to evaluate the necessity of an SPE or a golden share requirement if there were future proceedings concerning securitization or acquisitions or other circumstances that would really be tailored to those circumstances that that require an SPE or a golden share.
Questions? Please continue.
All right. MCC advocated for an annual report of compliance with the ring fencing provisions established under this final order under the restructuring plan as submitted by Northwestern and is modified by this restructuring settlement agreement. The restructuring settlement agreement, however, doesn't provide any sort of annual reporting. The draft order in front of you does include a paragraph that provides that Northwestern would provide an annual sort of summary of the notices that they would have to give under the restructuring settlement to the commission. And that summary would be attached to their annual reports, which are filed once a year for their electric utility, for their natural gas utility. Upon further consideration here, it is admittedly redundant. Paragraph 51 of the draft order, which would require reporting of changes in the long-term secured debt ratings, reporting of dividends issued by the Montana utility.
Mr. Hamilton, can I stop you there and
Yes.
clarify? Is it paragraph 51 or paragraph 50?
I will have to say that I believe it is paragraph 51 in the draft order as posed in front of the commission. And if you have a spare page there, that might be a spare page from a different draft.
Thank you, Mr. Hamilton.
Yep. So paragraph 51 discusses providing a summary of the notices made from the Montana utility to the Montana Public Service Commission over the course of the year. Where I left off, there is going to be a summary of dividends. There's also a summary of any transactions in excess of $10 million involving Montana utility assets. And then a summary of any transactions that involved the acquisition of merchant generation facilities by the holding company or its subsidiaries. Because the commission will be receiving notice of virtually all of these items as part of normal compliance with the restructuring settlement, and because much of this information, not all of this information, will be publicly available in corporate filings made by the holding company, the Montana utility, and affiliates. Staff does, on reconsideration here, believe that paragraph 51 can be removed as a redundancy to the existing notices the commission will receive. So to be clear, that what that means is that staff would recommend adopting the restructuring settlement as phrased by the parties. And as phrased by the parties, the commission receives notice of each of these items as they happen, rather than in a summary fashion at the end of the year.
So procedural question, as part of the motion, then do you recommend that the commission strike paragraph 51?
Mr. President, I would recommend that we rephrase paragraph 51 as it stands. Paragraph 50 describes the advocacy that the commission received up to the joint settlement. What I would propose for paragraph 51 is that you authorize staff to rephrase paragraph 51 to accept the the restructuring settlement as presented, which includes no sort of annual reporting. And if it suits the commission, of course, staff would be happy to provide that language to you for approval before it goes out the door after the commission has voted on this item.
I think I understand the questions. Go ahead, Mr. Hamilton.
Next is restructuring costs. Under the terms of the restructuring settlement, Northwestern and its shareholders would bear the entire cost of this proceeding and everything that was involved in this proceeding, including the retention of experts and whatever else. Anything related to this proceeding would be absorbed entirely by Northwestern Energy shareholders and not passed on to customers through rates at any point. It would not be the subject, for example, of a revenue requirement in the upcoming rate case, the pending rate case, or any future rate case proceeding. Because this protects customers from the costs associated with this restructuring transaction, staff does believe that it is reasonable and just and recommends approval of that restructuring settlement term.
Questions? Go ahead.
Lastly, MCC did recommend that the holding company should expressly commit to commission jurisdiction on any matters related to the enforcement of the ring fencing conditions established here, or any other conditions associated with the reorganization approval, and any matters related to affiliate transactions between the Montana utility and the holding company or its affiliates to the extent that they are relevant to the operations of the Montana utility. There is no such express submission to commission jurisdiction in the settlement agreement, but as I previously mentioned, the commission's jurisdiction is established by statute. It exists independently of the settlement agreement, of the restructuring settlement, I should say. And the commission's draft final order here makes clear that the commission does retain full jurisdiction as provided by law, as it now exists, or it may change in the future, depending on whatever the legislature may decide to do. So under the circumstances, I don't believe that it's necessary for the holding company to submit to the jurisdiction of the commission. The commission retains full jurisdiction under the law. As a result, we recommend approving the restructuring settlement as drafted without any express submission to commission jurisdiction for the holding company.
Do you have a clarifying question? Is there a motion?
Mr. President.
Mr. O'Donnell.
I did want to, it occurred to me when you're talking about the credit rating, was it addressed when one credit agency lowers theirs, but the other ones don't? Was that addressed at all?
Mr. President, Commissioner O'Donnell, it's a great question. The two agencies that this restructuring settlement focuses on are Moody's and S&P. And the thresholds are specified for each credit bureau, credit rating agency. So if S&P moves and it triggers the threshold, the entire threshold would be triggered regardless of what Moody's does. Did I say that right? One can move and trigger the threshold, and that would be enough.
Thank you.
Vice President Fielder, question?
I do, Mr. President. Thank you. When I was studying this earlier, it didn't occur to me, but I was just wondering, when I looked at the org chart for this restructuring, I didn't see Sleepy Hollow on there. Did they not acquire that, or is that lumped into one of these other subsidiaries?
Mr. President, Commissioner Fielder, this docket was initiated before the Sleepy Hollow process was complete.
Oh, okay.
So I believe that's why you don't currently see it in the corporate structure.
Thank you.
Mr. Hamilton, I do have some questions. So Montana Public Service Commission is not the only jurisdiction to have been requested to review the corporate restructuring of Northwestern Energy. Is that correct?
That is correct, Mr. President.
Would you walk us through
Yes.
which other state entities and or federal entity may have reviewed this?
Certainly, Mr. President, as described in the procedural history, or excuse me, I believe it's in the early findings of this draft order. The restructuring plan had to be submitted to each jurisdiction in which Northwestern operates. So that includes Montana, that includes Nebraska, that includes South Dakota. And of course, FERC on the federal level still regulates Northwestern. All of the other jurisdictional regulatory bodies that have reviewed the stipulation, excuse me, the restructuring plan have in fact approved it. Montana, perhaps because of the complications of the bankruptcy stipulation and the involvement of the Montana Consumer Council, did take longer, but we are now at the point where Montana Consumer Council, by virtue of this restructuring settlement, believes it is prepared, ready for commission action.
Thank you for mentioning the bankruptcy action. It's my understanding we as Montana were the only jurisdiction that was party to some agreement with Northwestern Energy regarding ring fencing provisions. Can you address that?
Be happy to, Mr. President. Included in your meeting materials for today was an older 2004, it's not ancient by any means, but a consent order that the commission had issued back in August of 2004 that approved the sort of joint, the bankruptcy stipulation between Northwestern Energy, the Montana Consumer Council, and the commission. So yes, the commission is in a unique position here of having been a party to that bankruptcy stipulation and having issued a consent order, an order that is still binding until substituted by the commission, which this final order would do, substitute in place of that bankruptcy stipulation.
And that bankruptcy stipulation has been in place since 2004, correct?
Mr. President, yes.
Okay, additional questions?
Mr. President, I'd just like to go back to this Sleepy Hollow. So how will that be addressed? I mean, it kind of sounds like a hanging chad right now. How will that be addressed under restructuring?
Mr. President and Vice President, I don't believe that it needs to be expressly addressed as part of this approval of the restructuring. So a good example of, let me back up here. The bankruptcy stipulation did prevent Northwestern from acquiring any sort of subsidiaries or having a new holding company within its corporate structure, but the commission has on past instances waived that provision. So for example, Northwestern Energy acquired the Haver Pipeline Company, and that was done through a docket where the commission expressly waived that provision of the bankruptcy stipulation. Likewise, I would construe the commission's action in approving the acquisition of the Sleepy Hollow distribution system as another instance of the commission expressly granting the approval to acquire a new subsidiary. So even though it is not presently reflected in the diagram included in Northwestern's application, and by virtue of that included as a sort of a visual in the final order here, it doesn't really need to be because it still exists within Northwestern Energy's corporate structure. And after this, you will still see, the Sleepy Hollow gas system exist as a subsidiary of the Montana utility.
I'm satisfied with that answer, Mr. President. I just want to make sure we didn't have something hanging there that we didn't take care of and had to come back to. Thank you.
Additional questions before I make a motion? Seeing none, I'll move forward with the motion. Then I will move to have the commission grant the joint motion to approve settlement, but to have paragraph 51 of the draft commission order revised to reflect settlement language as phrased by the parties, which would specify that there is no annual reporting requirement. Is there a second?
I'll second your motion, Mr. President.
Thank you, Vice President Fielder. We have motion and second discussion. Commissioner O'Donnell.
Thank you. I just wanted to thank the MCC for all their work on this. And when MDU reorganized, I became aware of the difficulties that were particularly with them, but it applied to this also in that in MDU, if one of their subsidiaries, Knife River, built a bridge and it collapsed, that the ratepayers would not be affected by that. So that clarified the issue for me, and I'm really happy that MCC and Northwestern have worked this out to agreement right there. And it looks like it's a very good, I almost said stipulation, settlement agreement on there. Thank you, Mr. President.
Additional discussion? Vice President Fielder.
Mr. President, I can see that there was a tremendous amount of work that went into arriving at this settlement, and I appreciate all the parties that were participants in that, and our staff's analysis has been excellent. I was happy to see this one finally come forward, because it just seems like a much cleaner way of doing business, and it'll, I think, be helpful for us as we the state of Montana tries to regulate the operations within Montana. I really like the distinction and the clarity that this brings.
No discussion. I will speak to my own motion on this one. Needless to say, colleagues, this is one of the more consequential matters that I've dealt with in my 2 years on the commission. I really appreciate, as was averred to by Commissioner O'Donnell, the parties to this proceeding coming together to reach settlement in this matter and to present the same to the commission for its analysis and approval. And I also appreciate, as Vice President Fielder stated, the very, very diligent work that was done by our staff to review the terms of the settlement proposal and to determine the consequences of the same and whether they were supportable. I would note, as Mr. Hamilton referred to during the questioning portion of this matter, that restructuring proposal has been approved by the states of Nebraska and South Dakota to this point. I would also note that the Federal Energy Regulatory Commission issued an order in late November of 2022 that rejected the protest submitted by the large customer group as to Northwestern's application for approval of corporate restructuring. FERC found the corporate restructuring, as I recall, to be in, quote, the public interest. I'd like to highlight the several provisions in the settlement that I believe that will protect the public and the ratepayer. First, I'm pleased that the agreement assures that Northwestern Energy's customers will not assume in any rates any of the cost of the corporate restructuring. I believe the ring fencing provision set forth in the draft order will ensure the PSC retains the proper authority to regulate Northwestern Energy's Montana operations. Ring fencing provisions will also provide comparable protections to customers against negative risk, as the existing ring fencing measures currently provide through the bankruptcy stipulation. So I see no diminution in the protections to ratepayers in Montana. The ring fencing provisions will serve to ensure that Northwestern's public utility assets, facilities, and operations are adequately insulated and separated from any non-utility ventures. Further, the settlement provisions, if adopted, will enhance measures that protect Montana's customers from any regulatory risk that may exist from Northwestern operations in Nebraska and or South Dakota. Further, colleagues, this agreement, if adopted, will require Northwestern to notify the commission of the sale or transfer of any utility assets over the amount of 10 million. You heard me ask Mr. Hamilton whether that 10 million was the original proposal by Northwestern. It was originally a 25. And so I think by bringing down that number to 10 million, I think we better assure the protections to Montana's ratepayers. So in sum, I believe the settlement terms as to be modified and adopted by this commission are consistent with the public interest, and I will be supporting it. With that said, if my colleagues would give me a little indulgence to speak to this matter, to provide a little history as to how we got here, which I think is informative to the public and need some elucidation to the public of the fact that here in the year 2023, we are still dealing with the consequences of Montana's decision in 1997 to deregulate Montana Power Company. I don't think many folks in Montana and or at the legislature understand the impact that deregulation had and is continuing to have some 26 years later. So with my colleagues' indulgence, I'll reflect on a little Montana history. Today's action is incredibly an action flowing from the wake of the problematic decision almost 30 years ago to deregulate the Montana Power Company. As I'm sure my colleagues are aware, in 1997, the then governor signed into law the Electric Utility Industry Restructuring and Consumer Choice Act. The then governor's decision to sign the Electric Utility Industry Restructuring and Consumer Choice Act into law is arguably the single worst policy decision in the history of the state of Montana. What followed is, of course, well known by Montanans and for those of us who work on the commission and work hard to protect the rate-paying public while assuring the adequacy of the operations of regulated utilities. As I stated, in 2023, as my colleagues know, we are faced daily with the consequences in the wake of that decision in 1997. As we all know, Montana's power rates exploded, going from some of the lowest in the nation to some of the highest in the nation. In Butte, that historic city contained within my PSC district, hundreds of dedicated employees lost jobs and Montana families suffered financially. Montana Power Company investors across the Treasure State saw their investments dwindle to little or no value. At one point, the stock was traded at an incredible 33 cents. Also, the value of employees' 401ks dropped significantly. People lost their means of retirement. And of course, relevant today to today's docket and our decision, history shows that by early 2002, Montana Power sold its transmission and distribution assets to Northwestern Energy. And of course, as history has shown, Northwestern had little or no generation assets at the time and was correspondingly operating under a legislatively imposed price cap scheme that basically forced Northwestern Energy into bankruptcy in 2003 as power prices skyrocketed across the country. And we all, of course, know what happened with the Enron situation. So here we are in 2023, some 20 years later, considering measures that revise provisions of consent order 6505E issued by the commission in September of 2004 that arose out of the bankruptcy proceeding. What has happened since what has happened since the 2003 bankruptcy? Well, in 2007, the Montana legislature, I think it was 2007, passed the Electrical Utility Industry Generation Reintegration Act, which authorized Northwestern to vertically integrate in the same manner as Montana Power Company operated for more than 80 years. And of course, the Montana legislature passed the pre-approval statute to help Northwestern Energy get back on its feet. Incredibly, this is a public policy decision that is still being played out in the halls of the legislature as we speak. I want you to think about that. What is more, in the last 20 years, the commission has considered the purchase by Northwestern Energy of an interest in Colstrip 4, as well as a purchase of Montana Power's company's hydropower assets, namely the 11 hydroelectric dams that were sold off to PPL Corporation in the aftermath of the 1997 legislation. You've certainly heard colleagues, folks talking about that the Montana ratepayer has paid for those assets more than one time as a result of the deregulation decision. All the while, deregulation has cost Montana's ratepayers millions upon millions in increased power bills. The point here is that Montanans, including those championing for deregulation in 1997, need to know that some 26 years after the former governor decision to sign electricity deregulation into law, there is not a day that goes by here at the Montana PSC where the agency is not dealing with some aspect or consequence of the 1997 electric deregulation decision, including this particular docket. So let me finish by saying the public will be wiser for knowing the truism that the mistakes of the past should be heeded so that they are not repeated into the future. So I encourage my colleagues to support this joint motion to approve settlement. Additional discussion?
Well, Mr. President, thank you for that history and the preparation you took to put that together. That was very enlightening.
Additional discussion? All right. All those in favor of my motion to grant the joint motion to approve settlement signify by saying aye.
Aye.
All those opposed signify by saying no. Seeing no opposition, motion carries Unanimously, Mr. Hamilton, let me commend you for the excellent work that you've done on this, as well as the regulatory staff. Your explanation was outstanding. Work session item number 4, which I don't know what it is on the publicly noticed agenda, but this would be docket 2022.09.085. This would be Aquanet Lindley Lakes. This would be the application for initial rates and charges. We're here to consider Aquanet's unopposed request to withdraw application and set interim rate of $80 per month. And Laura Zahowski.
Yes, Mr. President. Good afternoon, Mr. Chairman, Commissioners. I'll start, if I may, with a little bit of procedural history. On September 1st, 2022, Aquanet Inc. Lindley Lake Estates, who I'll refer to as Aquanet Lindley, filed an application for initial rates and charges. The Montana Consumer Council subsequently intervened in the matter. Then on January 26, 2023, Aquanet Lindley filed an unopposed request to withdraw application and set interim rate of $80 a month. And it's that request that you all are here to consider today. In this request, Aquanet asked for 3 things. The first is to withdraw its application that it filed on September 1st, 2022. As the request is unopposed, staff recommends that that request be granted. The second thing that Aquanet Lindley asked is that it be granted an interim rate of $80 a month for unlimited water and wastewater effective January 1st, 2023. Staff recommends that this request be denied for a variety of reasons. Among them is the fact that the request seeks retroactive rate making. There's no application upon which to base an interim rate. Aquanet Lindley is already charging its customers $80 a month for unlimited water and wastewater. And Aquanet Lindley has represented to the commission that it will file a new rate application no later than June 30th, 2023. Essentially, staff believes it would be most prudent to consider an interim rate if appropriate, in conjunction with the new rate application. The third thing Aquanet Lindley asked is that the current procedural order, which is procedural order 7874, be held in abeyance pending the filing of its new rate application. Staff also recommends that this request be denied. When Aquanet Lindley files its new rate application, it will be assigned a new docket. In turn, a procedural order, if appropriate, will be issued in that docket. So there's no reason to hold the current procedural order in abeyance in this docket. Now, in your reading materials, you will find a draft final order that incorporates all the recommendations I just mentioned. That order grants Aquanet Lee's request in part and denies it in part along the lines I just mentioned. So staff's ultimate recommendation is this: that the commission adopt as the commission's final order the draft final order found in the reading materials, and authorize staff to make further edits to the draft final order as needed to improve clarity without changing the disposition. With that, I and Mr. Fink would be happy to answer any questions you might have.
Thank you. Mr. Fink, anything to add?
No, President. Mr. President,
Motion.
question first. So by denying their request for an interim rate, because we have nothing to base it on, we're just we're not authorizing any rate at all. Is that correct?
Yes, Commissioner, that would be correct.
Okay, good, thank you.
Is there a motion?
Yes, I will move to accept the staff's recommendation on this Aquanet and Lindley Lakes, Mr. Chairman.
All right. Is there a second? Vice President Fielding.
Second the motion, Mr. President.
All right. Discussion, Commissioner O'Donnell.
This has been a convoluted issue, and I really appreciate the forbearance the staff has given to this. At a meeting, what was a month ago, or at the beginning of February, we allowed them to answer some questions to sort of hurry this thing along. As I understand it, their response to our request for information was to withdraw their application and start all over again, which I think is the proper way because what they were asking for was really contrary to commission rules and procedures. So I think this is a very clean way of doing it. And I really appreciate all the staff work on this, working with them and with the commission. I appreciate that, Mr. President.
Thank you, Commissioner O'Donnell. Additional discussion? All right, seeing none, all those in favor of Commissioner O'Donnell's motion to approve Aquanet's unopposed request to withdraw application signify by saying aye.
Aye.
Aye. All those opposed signify by saying no.
Mr. President, I believe the motion was more inclusive than just that number one item. It's also to decline the other requests that was made.
Yes, Mr. President, Mr. Commissioner, that's correct. The recommendation is that the commission approve the draft final order that's in the reading materials, which approves the request in part and denies it in part.
All right, thank you for the clarification. We'll vote again. This is the motion as stated. All those in favor of Commissioner O'Donnell's motion signify by saying aye.
Aye.
Aye. All those opposed signify by saying no. Seeing no opposition, motion carries. As noted, Northwestern Energy's 2023 Electric Integrated Resource Plan for us to issue an RFP has been deferred. So my agenda item 6 is legislative update. Mr. Hamilton. Colleagues, we will have a more truncated legislative update today because Mr. Rosequist is ill. I have asked Mr. Hamilton to fill in as best he can. Mr. Hamilton.
Thank you, Mr. President and Commissioners. We will be very truncated today. I can report on 2 bills that were heard yesterday in the House Energy Technology and Federal Relations Committee. I did attend that committee meeting to provide informational testimony on one of the bills. So we'll start with the bill that I did speak on. That is House Bill number 558, introduced by Representative Galloway. The bill would amend the Montana statute that discusses the deposition of witnesses in commission proceedings. In particular, you may recall we dealt with this statute in the Northwestern Energy General Rate Case in the deposition of Cindy Fang as requested by 350 Montana. 350 Montana asserted that the statute, which is Title 69, Chapter 3, Section 328, allows both the commission or any party to a proceeding before it to cause a deposition to be taken in the manner prescribed by law for like depositions in civil actions. So 350 Montana's position was that they have a right under the statute to conduct the deposition and that they do not need to come to the commission and ask for approval to conduct the deposition in the first place. You may also recall that commission rules currently do require parties to come to the commission first before conducting a deposition, or really using any mechanism of discovery outside of the data request and response process outlined in commission rules. So this bill by Representative Galloway, I think is clearly aimed at precisely that scenario. It would clarify, at least as I understand the bill, that the commission can cause a deposition of a witness can be taken, and commission rules can allow other parties to conduct depositions. So again, under the current commission rule, that would mean that parties need to come to you first and ask for leave to conduct a deposition, and then you would evaluate based on the circumstances whether a deposition is appropriate.
Just to clarify, when you say the word parties, you mean parties to that docket item?
Mr. President, Commissioner O'Donnell, that is correct. Yes, it is parties to a specific docket attempting to conduct discovery by deposition in that docket.
Vice President.
Just for clarification, you went in as an informational witness, is that correct?
Mr. President, Vice President, that's correct at the president's request.
Okay, and when was that hearing? Because our update says that hearing was canceled. So was that yesterday or?
Yes, Mr. President, Vice President, it was yesterday, 3 o'clock, the meeting of the committee.
Thank you for working on the holiday for us.
We were, yes. Thank you, Vice President. So let me take a moment to commend Mr. Hamilton for his diligence and dedication to this agency, because we were notified about 8:30 yesterday morning that that hearing was going to take place on a state holiday. And I called Mr. Hamilton and interrupted his day off, if you will, to which he was entitled, and asked him to cover that hearing for us, which he did. So thank you, Mr. Hamilton.
Thank you, Mr. President. I'll get it back some other day here. We'll find a way. Are there any other questions or commission discussion on House Bill 558?
Did the committee take any action on that?
Mr. President, Commissioner O'Donnell, no. The committee began their meeting with executive action on 2 other bills, but gavelled out as soon as the hearing on 558 was concluded. So I imagine they'll be considering action soon.
Was there any substantive opposition or support from the bill?
Mr. President, Commissioner O'Donnell, Northwestern Energy appeared and supported the bill. Chris Puyer was the lobbyist for Northwestern Energy. A representative from MEIC appeared and opposed the bill. And of course, commission appeared only as informational witness. Questions from the committee during the hearing were only directed to the commission about the process, the current methods of discovery in front of the commission, and how this particular issue worked itself out in the Northwestern general rate case.
So, Mr. President, one more. My question about a party to that particular specific docket, is that analogous to what we hear about that in any judicial proceeding, somebody has to have standing? Is that so what this would do, it would preclude some party that has an interest in it, but is not part of the docket from intervening and inserting themselves into the process. Is that correct?
Mr. President, Commissioner O'Donnell, it would require as a threshold matter that a party be a party, that you, the commission, have granted intervention to one of those parties, or potentially in the case of a complaint, you have a respondent, right, appearing in front of the commission by virtue of being named in the complaint to appear in front of the commission. So those are the sorts of parties that we're talking about here. The question of whether a party has standing is a question to be resolved at the intervention stage. A question of whether they satisfy the commission's rule for intervention in front of the commission to participate in a proceeding, which is slightly different, at least as the rule is currently phrased, than traditional constitutional civil standing in a court of law.
Thank you.
Additional questions? All right, go ahead, Mr. Hamilton.
Right. The committee heard one other bill that I can report on, and that I suppose is actually not a bill. House Joint Resolution number 6, sponsored by Representative Zolnikov, would direct over the interim a study to determine whether to require utilities and wholesale electric generation suppliers to either have, contract for, or participate in a pool for electric generation reserves, and to determine when reserves should be made available for a balancing authority managing electric load, so Northwestern Energy, the balancing authority for most of Montana, to decrease the probability of service interruptions and to enhance reliability while remaining in compliance with NERC standards, NERC being the North American Electric Reliability Corporation. So the idea of this joint resolution would be to address concern that the commission has had and has explored in recent months here through the conference that the commission held back in December of last year, and through the roundtable that commission staff held with representatives of the co-op community and large customer group to discuss how, and Northwestern, I should include Northwestern in that discussion, to discuss how the state of Montana can better prepare for sort of extreme weather events, to prepare for the instances when a generation resource may not deliver, may fail to deliver as scheduled, and avoid the sort of emergency scenario on the transmission system that forces blackouts, that forces an interruption of electric service to customers across Montana. So this is a joint resolution, as I mentioned, so it's a study bill. It will be studied over the interim. There was no opposition to this study at the hearing. In fact, there were representatives from Northwestern Energy, MDU, the co-op community, and Renewable Northwest. I believe that covers off the top of my head all of the supporters that appeared yesterday to speak in favor of the joint resolution.
Mr. O'Donnell.
Does the resolution specify who would make up that study panel?
Mr. President, Commissioner O'Donnell, per the language of the joint resolution, the Legislative Council would designate an appropriate interim committee or statutory committee to direct sufficient staff resources to study these matters. So I would imagine an appropriate interim committee, potentially the ETIC committee, would be tasked with this particular study.
Vice President Fielder.
I was just wondering, Mr. President, would you like the agency to monitor this? Or do we need a motion to do that, or just let it flow through?
Yeah, motion would be good. Would you mind making the motion?
I would not. I'd move that the commission monitor this House Joint 6.
Seconded by Commissioner O'Donnell. Discussion? The only thing I would note is that if my colleagues get the opportunity, I would go watch the hearing on House Joint Resolution 6, and particularly I would go listen to the absolutely quality testimony that was provided by the representative from the electric co-ops. It's one of the best pieces of testimony I've heard in my many years of being associated with the Montana legislature. It was tremendous, and I learned a lot, frankly, from it. Any more discussion on Vice President Fielder's motion? Seeing none, all those in favor of motion to have the agency monitor the bill signify by saying aye.
Aye.
Okay, next.
Mr.
Anything else?
President, I believe that is all that I am qualified to report on today. I, of course, wish Will a speedy recovery.
Indeed, if you're listening, we wish you a speedy recovery. We miss you already.
And Mr. President, wonder if we should have a brown bag on listening to that hearing or watching that hearing. That might be a good lunch topic to get everyone together that wants to learn. Sounds very good.
Yeah,
We could
Excellent
bring
suggestion.
popcorn and everything.
We would not be expending agency resources for buying popcorn, of course. Yes, Commissioner O'Donnell. Thank you. All right, seeing no further work session business, just some announcements. Tomorrow, Wednesday, the 22nd at 3:00, the House Energy Committee will hear House Bill 492, which is our final and last agency bill. To make its way into the process, this bill would repeal various parts of Montana code dealing with antiquated, unnecessary, or preempted code provisions dealing with telecommunications regulation. Our next commission business meeting will be in 2 weeks, so it will be March 7, 2023. And for the public's awareness, we will be having a contested case hearing next week here at the commission. Seeing no further business to come before the commission, the time is now 2:48 p.m. and I will adjourn this meeting.